Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In one of my previous videos, I told you that Honorable Supreme Court of India clearly stated that the bail arguments need not be lengthy. The bail orders also need not be lengthy. Of course, but they should not also be slipshod. That means they have to give a reasoned decision for denying the bail, or they should give a speaking order for granting the bail. But they need not be too lengthy. At least 10 minutes time is sufficient to argue on a bail petition. But in Delhi High Court, a case was heard over 40 days. For what? For bail. So this is a peculiar case called as Sharjeel Imam versus State of NCT, Delhi. So actually, more than this Imam, if you know, the main name is Umar Khalid. So that is 2020 Delhi rights regarding that Citizenship Amendment Act. If you know that, so it is very easy to identify this Imam also. While denying bail to Umar Khalid, Honorable Delhi High Court, they have commented that the main conspirator or the main actor is Mr. Imam. We know that there was long communication between Umar Khalid and Imam. Therefore, we are refusing bail to Umar Khalid. So, actually, this is previously it was the bail application of Umar Khalid, where Honorable High Court of Delhi commented against Mr. Imam. So, therefore, Mr. Imam filed an SLP before the Honorable Supreme Court of India to expunge the remarks made by the Delhi High Court. The matter has come before Justice Sanjay Kishan Kaul bench. Justice Sanjay Kishan Kaul, you know that he is the senior most judge in the Honorable Supreme Court of India. So yesterday, that is on 9/12/2022, S.K. Kaul disapproved the practice of filing lengthy bail applications and arguing as though it is an appeal petition or as if a conviction has already taken place. So this is the comment on him. So the crux of the orders are that the bail application or the bail arguments should not exceed, bail application should not exceed 4 to 5 pages, and bail arguments need not exceed a period of 10 minutes. Right. So as far as this case is concerned, the Sharjeel Imam, while hearing the plea of Delhi rights accused, Sharjeel Imam, who moved the Supreme Court to expunge the comments made by the Delhi High Court against him. And of course, already Delhi High Court has denied bail to Umar Khalid, and Supreme Court clearly stated that the orders of Umar Khalid, the orders of not granting bail to Umar Khalid, will have no bearing on the bail application of the so-called Sharjeel Imam. That's only a separate issue. ఇక్కడ విచిత్రమైనది ఏమిటంటే ఉమర్ ఖలీద్ అనే వాడికి బెయిల్ గ్రాంట్ చేయడానికి రిఫ్యూజ్ చేస్తూ దాంట్లో ఇమాం మీద కామెంట్ చేసిండే వీ నో దట్ హీ ఈస్ ద మెయిన్ పర్సన్ అని అతను బెయిల్కి వేసినప్పుడు అది కరెక్ట్, దానికి దీనికి సంబంధం లేదు. ఇట్ కెన్ బి టేకెన్ అప్, అదే అనమాట మెయిన్. సో వీ కెన్ కాల్ ఇట్ యాజ్ ఆర్బిటరీ డిక్టా, రైట్. సో హియర్ అసలు ఈ పాయింట్ పోయి తప్పు ఇక్కడ వచ్చిందంటే సంజయ్ కిషన్ కౌల్ ఎక్స్క్లెయిమ్డ్ bail opposition petition need not be so lengthy. So just like appeals as though conviction has taken place. But the advocate on behalf of Imam, Mr. Siddharth Dave, he explained that. So please remember, this is UAPA Act or UAPA Act 1967, Unlawful Activities Prevention Act. Particularly section 43D of the UAPA Act says, so the bail should not be easily given. The bail can be given only when the allegations are actually not proved beyond all reasonable doubt. So So the allegations, unlawful activities, they'll begin 1, 2, 3, 4. Suppose if I see the charge sheet or if you see the FIR itself, the charge sheet may run into hundreds of pages against all these persons. So therefore, the arguments also may be exceeding the so-called 10 minutes time. So in this connection, the way agreed that, no doubt, Your Honor, my Lord, the bail application should not exceed 10 minutes. But please remember, basing on the case diary, basing on the charge sheet, basing on the remand report, therefore, basing on the other things also, you have definitely you have to cut short or you have to cut it into pieces. Definitely you have to argue on the, so the remand report is like this. The FIR is like this. So they are lengthy. Therefore, we are getting more time. Yeah, so Sanjeev Krishna said, yeah, you got a point here. But anyway, ultimately, the judge here, of course, the matter is different. The judge clearly stated that, please remember, the bail application should not exceed 4 or 5 pages and bail arguments may not exceed 10 minutes. This is the general time. Of course, people will take their own time. But anyway, their observation has come by the Honorable Supreme Court of India. As advocates, you have to know all these things. Therefore, I am making this video. Thank you very much.